Spain adheres to the GDPR, which is directly applicable across the EU. Additionally, the national legislation, notably the Spanish Organic Law on Data Protection and Guarantee of Digital Rights, LOPD-GDD, further refines and supplements the GDPR to address specific national priorities and contexts. The Spanish Data Protection Agency, AEPD, is the national authority responsible for monitoring and enforcing data protection laws, offering guidance and resolving complaints regarding data protection violations. Data subject rights. Under the GDPR and the LOPD-GDD, data subjects in Spain are afforded numerous rights, including the right to access, rectification, erasure, restriction of processing, data portability, and objection to data processing. Additionally, the LOPD-GDD introduces specific provisions related to digital rights, such as the rights to digital education, protection of minors on the Internet, and the right to digital disconnection in the employment context. Obligations of data controllers and processors. Data controllers and processors in Spain must adhere to the principles of lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality. They are required to implement appropriate technical and organizational measures to ensure data security, conduct data protection impact assessments for high-risk processing, and report data breaches to the AEPD and affected individuals in specific circumstances. Enforcement and sanctions. The AEPD has the authority to impose administrative fines as per the GDPR, which can reach up to €20 million or 4% of the annual worldwide turnover of the preceding financial year, whichever is higher, depending on the infringement. The law specifies various levels of infractions and sanctions, emphasizing the need for sanctions to be effective, proportionate, and dissuasive. Online privacy and electronic marketing. Online privacy in Spain, including the use of cookies, is regulated by both the GDPR and the Spanish Act on the Information Society Services and E-Commerce, LSSI. Data controllers must inform individuals about the use of cookies and obtain their consent. For electronic marketing, consent is a key requirement, and the LOPD-GDD upholds that consent must be freely given, specific, informed, and unambiguous. The role of Data Protection Officer, DPO. In alignment with the GDPR, Spain mandates certain organizations to appoint a Data Protection Officer, DPO. These include public authorities, entities engaged in large-scale systematic monitoring, or those handling large volumes of sensitive data. The DPO's role is pivotal in ensuring compliance with data protection laws, acting as a point of contact for the supervisory authority, AEPD, and advising on data protection impact assessments, DPIAs. Cross-border data transfer. For businesses operating across borders, the GDPR and Spanish law provide strict guidelines on cross-border data transfers. Transfers of personal data outside the EU, EEA are permitted only under certain conditions, such as adequacy decisions, binding corporate rules, BCRs, or standard contractual clauses, SCCs. Spain, through the AEPD, ensures that these transfers maintain a level of protection consistent with EU standards, safeguarding citizens' data against unauthorized access and misuse. Sensitive data and special categories. The handling of sensitive data, or special categories, of data, is subject to additional safeguards in Spain. This includes data pertaining to racial or ethnic origin, political opinions, religious beliefs, trade union membership, genetic and biometric data, health data, and data concerning a person's sex life or sexual orientation. Processing such data is generally prohibited, except under specific conditions, such as explicit consent or necessity for reasons of substantial public interest, provided that appropriate safeguards are in place. Implications for businesses. Businesses operating in Spain must navigate a complex regulatory landscape. Compliance is not just about avoiding fines but also about building trust with consumers and protecting the organization's reputation. Businesses are encouraged to adopt privacy by design and by default, embedding data protection into their processing activities and business practices from the outset. This proactive approach to data protection can serve as a competitive advantage, demonstrating a commitment to customer privacy. The right to digital education and protection of minors. The LOPD-GDD underscores the importance of digital education and the protection of minors online. It advocates for the safe use of digital services, promoting digital literacy among children and young people. This includes ensuring that digital platforms provide age-appropriate content and afford protections against exposure to harmful or inappropriate material. Impact on individuals. For Spanish citizens, these regulations empower individuals with greater control over their personal data. The right to be informed, the right to access, and the right to be forgotten are pillars of data protection that enable individuals to understand how the data is used, access their data, and request deletion under certain circumstances. These rights are crucial in the digital age, providing a means for individuals to protect their privacy and manage their digital footprint. Conclusion. Spain's commitment to privacy and data protection is evident in its comprehensive legal framework and the active role of the AEPD. By balancing the rights of individuals with the needs of businesses, Spain fosters a secure and trustworthy digital environment. As technology evolves, so too will these regulations, adapting to new challenges and ensuring that Spain remains at the forefront of data protection and privacy. This ongoing commitment is vital not only for the protection of personal data but also for the advancement of a digital society that respects privacy and fosters trust.